Good afternoon, everyone, and welcome to this Only One Theme talk series, which we have been running since the last September 2022. And today is the 18th talk in this series, which is supposed to be the last talk in this current round. We do plan to come back with few more interesting topics, and towards the end of today's talk, I'll ask you about few topics which you might find of interest in the upcoming round. So today is the 18th talk in this talk series, which is focused around innovation management. And the topic for today is collaboration agreements. Our speaker is Mr. Nihal Kothari. Welcome, Nihal, to the session. Let me briefly introduce Nihal. Nihal is an associate partner at LegaLogic with extensive experience in technology and corporate law. With over 15 years of corporate exposure, he specializes in privacy, technology, and international commercial laws. Leading various teams at LegaLogic Consulting in Pune, Nihal provides expertise in software non-compliance, data protection, and privacy, insurance advisory, disruptive technology, and global commercial contracts. His expertise includes advising on complex privacy issues, structuring international data transfers, software asset management, insurance portfolio management, and commercial contract drafting and negotiation. Nihal's pragmatic approach and niche understanding make him a valuable asset in addressing legal challenges in these domains. So Nihal, with this brief introduction, welcome to the session and handing over the session to you.
Yeah, thank you, Mugdha. Thank you, Dr. Premnath, and thank you, Venture Center, for this opportunity. First of all, it's a pleasure and honor to be here. And we always look forward to, come and talk or, be participant in some of these knowledge sharing sessions. And you guys are doing amazing job. So, hats off and congratulations to you. Now, before I start this session, I want to present the position and a perspective from where I'm going to address this session. I represent LegaLogic today, and I lead a team of lawyers who exclusively deals with commercial contracts, negotiations. We draft, we review contracts, we advise our clients on different risk mitigation techniques. We also do their litigation, we give them opinions on employee issues. So whole gamut of things that we do, and this is industry agnostic sort of a conversation. So we work with technology companies, startups, manufacturing companies. We represent different IT companies, and that's the portfolio. Now, the reason why I'm sharing this is, as a part of this work that we do in LegaLogic, we get to very closely witness the journeys of companies at different levels, and they are all going through different, growth journeys. And I have very closely seen successes and failures that the companies go through, more specifically in the context of collaborations. I've seen many companies scaling up greater heights just because they had great collaborations and they had thought through their strategies really well. And I've also come across companies where they're sort of struggling with the collaborations that they have got into because they had to sign certain unfavorable contracts. So today I'm going to be sharing all of these experiences through certain practical insights in terms of how we should look at collaboration as an opportunity and collaboration agreements most specifically. And in my topic, I'm going to be talking about collaboration. I'll be talking about certain exemplary concepts about collaboration. I have given very specific examples that I'll be talking about. I'm also going to be covering the key nuts and bolts and nuances when we talk about any specific collaboration agreement. What is the broad level skeleton of any collaboration agreement? I'll cover certain legal concepts. And again, the idea is not to throw a book at you, but I think it is important that as a collaborator or as a business, if you are entering into any collaboration opportunity, you need to have some basics cleared in terms of those legal concepts. I do have some case studies that I have picked up for you. There are use cases and some real life examples that I'll be talking about. And after that, I'll be actually at the end of this session, and I think we do have around 50 minutes or so. So it's a power pack session. I'll try and cover as many topics as I can. And then at the end of this session, I'll be actually taking your questions if you may have. So with that, I'll share my screen and then we can proceed into this session. I hope you can see my screen now.
Yes.
Yes.
Okay. All right. So as a lawyer, what we love most is, lawyers, I'm sure you must have come across, they always talk about certain disclaimers, whether it's their legal opinions or with whatever they, you do. So I do have two disclaimers. The first and foremost is, this is not to be construed as a legal opinion. This is not the firm's view. This is purely for your academic interest. And I have, for your convenience and for you to be able to relate to some of these examples, I have used different logos and brand names of real life companies. Again, the idea is not to infringe upon anyone's IP. It is just to make this session more relatable to you. So these are the two broad disclaimers that I thought I should put it first. Now, let me first quickly talk about as a baseline, and I think it is prudent for us if we could quickly spend a minute to understand the very concept of what the collaboration is. Yeah. So I think I'm just getting some messages. Just one second.
Sorry, Nihal, can you keep your video on, please?
I do have some different reference points, so I'll come back with my video in some time, sir. If you don't mind.
Okay, sure, please.
Yeah,
Go ahead.
thank you. Because I have a lot of facts that I need to refer to, so I thought I'll just not
sure,
use
please
my
go ahead.
video today. Yeah, thank you. So when we talk about collaboration, it simply means a mutual partnership. It's a working relationship between two or different parties for the purpose of achieving a shared goal or an objective. And collaborations typically involve a joint effort or a contribution of multiple individuals, organizations, or entities who come together with a combined domain knowledge, technical know-hows, IP, sophisticated machinery, some sort of a capacity in the market, their market position, or their market hold, or their ability to fund or to accomplish a particular task. Now, if you look at collaborations, those are commonly found in different sectors. Business sector is the most common. You will also see collaborations happening in R&D sector. You will see collaborations being very widely used now in entertainment, arts, OTT platforms. Influencers use collaborations. You look at different technology collaborations frequently. And then, of course, there are NGOs who are also using collaboration as a concept beautifully well. Now, let's deep dive into and what you see on your screen is I have jotted down some most common motives or drivers behind collaboration that I see as a commercial attorney. And again, this is definitely not an exhaustive list. Collaboration always enables pool of resources. It could be in the form of expertise, knowledge, technology, infrastructure. And you can actually overcome some individual limitations by collaborating with someone. Now, different organizations always bring unique perspectives, and their ability to problem solve any particular issue could be different. And naturally, it culminates into some sort of innovation. So collaboration always fosters creativity and innovation. So that's the second driving factor. Collaboration also helps to distribute your risks. And if not completely, it actually lowers the impact of those risks. And I have seen that happening very closely when we talk about very high risk projects where the outcome is uncertain, but because you have collaborated with someone, you are taking a calculated risk. Now, if you've collaborated with a partner who has well-established presence in specific market, that can enable certain untapped opportunities for you, certain customer segments for you, certain distribution networks, and new geographies. Collaboration also helps you to scale up your business real quick. Now, I have used this term called as synergistic effects, and I firmly believe that collaboration has synergistic effects. And what I mean by that is, if two collaborators come together, they streamline their processes really well. They can improve the efficiency and they can provide great output together. So collaboration has that as one of its great advantage of synergistic effects. Now, if you're collaborating with a reputable partner, it automatically also enhances your brand reputation and brand image. If you've partnered with someone who has got access to resources, funds, equity, investment, or that collaborator, your collaboration partner is well connected, your chances of securing funding also automatically increases. Now, I have not covered few more, but if you look at certain regulatory compliances, or if you want to bid for any government project, uh, it is one of the prerequisites that you need to have some capital, you need to have certain license in place, and again their collaboration helps you. And last but not the least, the net effect of collaboration is you become more competitive, you get a more competitive advantage when we talk about concept of collaboration. Now, quickly, let's look at the different types of collaborations. And I'm going to, I have picked up certain logos for you. These are the, cases that I have picked up for you to be able to relate to those very well. So let me start. So the first one is co-branding opportunities or co-branding collaboration. This is nothing but some sort of a strategic partnership for marketing and advertisement between two different brands, where the success of one brand actually determines the success of its partner brand. And I think Nike and Apple did that way back in early 2000 when Apple was actually launching the iPods. They created fitness trackers and clothing line that tracked activities while connecting people to their iTunes back then. And recently, they've also built activity tracking technology into athletic clothing that actually syncs your iPhone apps for tracking and recording the workout data. So it that synchronization happens real time. So that's how they have played into co-branding collaboration. Now let me talk about the second one, which is the technical collaboration. Now, under the technical collaboration, two or more entities come together and they share their technologies that complements each other, and then they tap into each other's market. And I couldn't think of any better example than Toyota and Suzuki in India. They signed a collaboration agreement in 2017, and since then, they have been bringing together Toyota's real strength, which is EV, electrification technologies, and Suzuki's strength, which is production of compact vehicles together, and both are mutually producing and supplying vehicles globally now. Now let's look at the next type, which is the R&D collaboration. And R&D collaborations generally are of two types that I know of. One is it has this social characteristic or a nature where those collaborations are done for the research and development of certain greater cause to benefit the society. And the second type of R&D collaborations are purely business driven, where those are done for technological advancements, creation of some sort of a competitive products, and they do offer some sort of value added services. So the classic example here that I could think of was in 2020, GSK, which is a pharma giant, and Veer Biotechnology, which is a commercial stage immunology company, entered into some sort of a collaboration agreement to develop solutions for coronavirus and to reduce the outbreak of COVID-19. They use Veer's proprietary monoclonal antibody platform technology to accelerate the then ongoing research that GSK had already taken to come up with this antiviral antibodies. Eventually, we went solo on this effort, but even today they pay some royalties to GSK. So that's a classic example of R&D collaboration. Now the next one is interesting, which is exclusive collaboration, and we're going to spend some time on that even in this section of this session, and then subsequently I'm also going to be talking about exclusive collaboration because I think it is one of the important ones. And when I was doing some research for this session, I stumbled upon this fact from Spain. And interestingly, only half of the sales that you see at gas stations in Spain actually come from sale of petrol, diesel, or gas. The other half sale actually comes from high value products, services that are offered to the customers through the adjoining shops. And I think Repsol, which is Spain's one of the leading gas station oil and gas company, actually partnered and collaborated with fast food giant Burger King, and they signed actually an exclusive deal where Repsol has secured an exclusive right to have Burger King franchises across the entire Spain in gas stations. And automatically, both the companies have benefited. I'll talk about, as I mentioned to you earlier, I'll also talk about those exclusivity aspects in greater detail in one of the next slides again. Now let's quickly touch upon franchisee collaboration, and I don't think I need to explain those beyond the basics because they are well known to all of us. You create a brand, you create some standard operating procedure, you decide the distribution network, you pick up your suppliers, you standardize the experience, you earn some success, you decide the revenue model, you keep an eye on your franchisee through auditing, and then you are ready to roll out a franchisee model. And that's how you grow your business. And of course, franchisee has its own different variations. Company owned, franchisee operated, franchisee owned, company operated, franchisee owned, franchisee operated. So COFO, FOFO. These are different models that exist. The next one is the build, operate, transfer, or build, own, operate, and transfer collaborations. And these are generally large scale infrastructure projects where a private entity receives some sort of a concession from a public sector. And at times nowadays, there are also private players who are involved to sponsor those BOT collaborations to either finance, to design, to construct, to own, and then eventually operate that facility. Now, the private entity will have the right to operate the facility for a certain time in order to recover the investments made through operation and maintenance contracts, etc. Now, the road constructions in India is a good example of BOT model where after they're done with the road construction, they actually install those toll booths. And that's a classic example of BOT model. Now, let me quickly talk about the consultancy collaborations. And under this arrangement, the professional consultancy firms tie up with the original equipment manufacturing companies. And this is some sort of a preferred or widely used model that we see in IT and ITS domain, where they provide professional services ranging from management consultancy, finance advisory, to implementation or customization of OEM software as per the client needs. And you'll see on your screen, countries' leading system integrators are classic examples of consultancy collaboration. Now, on the academia side, the academia and industry collaboration, I think it's very simple. The industry partner collaborates with any academic institute. They provide funding, they provide resources, they provide some practical insights, and they support to those academic institutes in a way that in exchange, they either get certain research findings, certain inventions, or at times, they're looking at some good talent being sourced. So the subject matter and the scope of those collaborations could vary, but the format and the skeleton of those engagements when we talk about industry and academia remains the same. And I'll fall short of time explaining and giving examples of industry academia, but if you look at the leading premier institutes in India, like IITs, they've partnered with different industry leaders at different levels to foster innovation. Now, the next one that I have picked up, this is slightly non-standard, but we see a trend that is happening, which is two competitors coming together and they're collaborating, or multiple companies coming together and collaborating, and those are for different causes. One of the important causes that we see is open source projects, and Linux operating system is one classic example where IBM's, Red Hats of the world, they came together under an open source project to develop some shared technologies and certain standards. And that's one use case that we see here. The second one is interesting, which is the Better Cotton Initiative or Open Cotton Initiative, where leading fashion industry brands like Nike and Adidas came together to form sustainable cotton sourcing and farming practices. So if you think on those lines, you will find many more such examples. Let me talk about the smart collaborations now, which is nowadays getting very common, where two tech companies come together, they collaborate together, and they bring new experience. They cross-sell into each other's market. And if you happen to use Spotify and Uber, the users of the Spotify now may link their Spotify accounts and enjoy their favorite tunes while even riding in an Uber. And if you happen to have a paid Spotify sort of an account, then even after you have booked your Uber, till the time that Uber comes, you could very well enjoy Spotify on Uber. So they've done a seamless integration, and that's how you do a cross collaboration with each other. Now the next one, which is one of the most common collaboration that you see in the industry, is a corporate entity and a startup entity coming together, either through equity or non-equity, but it's more of a strategic sort of a collaboration. And the classic example is Colgate-Palmolive way back in 2018. They made a strategic collaboration with the men's grooming brand called as Bombay Shaving Company. This was a strategic sort of a collaboration to both the entities, as the Colgate-Palmolive actually they wanted to test the men's grooming market in India, which is relatively a new space. And at the same time, the Bombay Shaving Company actually received complete access to Colgate-Palmolive, which is a huge multi-billion-dollar company. The Bombay Shaving Company received access to different market channels, different experiences, the supply chain networks of Colgate-Palmolive, and therefore it's a win-win situation for both the entities. Now, the next one is teaming collaborations, and what you see on your screen are the three different broad level teaming collaborations. And again, this is definitely not even an exhaustive list, but I have tried to pick up the common ones here. So referral is where you refer one customer to your partner, and what you get paid is some sort of a referral fees. It's a success-based fees that you receive after you have referred that particular company, and that company has got converted into a client. And generally, the payment terms are back to back. White labeling, on the other hand, is where you take somebody's services or a product. And generally, white labeling arrangements or collaborations are very common when we talk about product or goods, and this is more prevalent in either manufacturing sector or IT or ITS sector, where you take those products, you white label those, you rebrand those with your name, you go in the market and you sell. And of course, in the back end, you have your the original equipment manufacturer or the original licensor of that software providing you that back end support which is required. But at any given point in time, your client does not know that this is a rebranded product. Of course, there are certain exceptions where companies do negotiate something where they say that fine, you go and you sell my product under your brand, but you at least say it is powered by so and so. So these are some of the variations that you see in the white labeling scale. And the third one is the subcontracting arrangement. And this is very interesting because many times you have got a good market reach, but you do not have the capacity or expertise to do certain set of services or provide certain set of goods. So you tap into partnering with someone who has got that capacity or expertise. You go and you take the business, or you bid for it as a prime bidder. You take that business, you take all the liabilities associated with that work, and in the background, you actually subcontract or outsource that work to your subcontractor. So that's called as a subcontracting arrangement. Now, in the subcontracting arrangements, or even for that matter, white labeling arrangements, you're always going to be the face. And therefore, contractually, you will tend to pass on your liabilities to your partner, the collaboration partner. So, these are some of the types that we see when we talk about teaming sort of and collaborations. Now, the next and probably one of the most important one is, licensing and assignment collaborations. And I have just picked up the example of technology licensing, but I should have used the word IP licensing here, because this is not specific only to technology. And I have brought in certain examples where you'll understand people are doing too many different variations now, and the market is leading towards a lot of creativity when we talk about licensing. But simply put, the difference between licensing and assignment is in a licensing arrangement, you only transfer the ownership. You do not transfer the ownership. My apologies. You just give a limited right to the other party to use your IP. It could be anything. It could be your invention. It could be your software. It could be some know-how or a proprietary process or trade secret. But you continue to remain the owner, and what you provide is a right to use. The other party could commercially exploit that software or IP, or they could use it for any predefined purpose. It could be just for their internal use also, in exchange of certain license fees. And you can actually decide the rules of your engagement with that other party in a license agreement. But in a way, those are also collaborations. And anything which is not licensed, where you outrightly transfer the ownership for in exchange of certain fees or consideration, that definitely is then legally treated and termed as assignment. So collaboration, technology transfer, I think you already have gone through a very detailed session on that, and I need not have to talk about it. But that's the key difference. Now, when we talk about licensing collaboration, your fees are generally either lump sum fees, or there will be some volume production for which there is a running royalty that you could get paid. The third one is interesting, where it also is some sort of a barter system where you give your license to your partner, and in return, you also have one license back from the partner. So it's some sort of a barter that you see. That's another different form of engagement under the licensing that we see when we talk about collaborations. Now, let's understand the licensing concept through some use cases. And I have picked up one slightly different example. It's non-standard example, but this will give you an idea as to how licensing could be used beautifully. And this is about licensing in relation to the museums. So if any one of you follow the international museum space and the art space, you would know that the Louvre in France is a well-known museum in the world. And in 2007, the French government actually struck a licensing deal with the Abu Dhabi corporation for whopping $1.3 billion. Now, through this deal, Abu Dhabi government actually has permitted or is been granted to open a new museum in Abu Dhabi, which is already up and running, called as Louvre Abu Dhabi. And the Louvre France actually licensed its own brand name. It also actually flew some of the very rare and some of those very costly artifacts and exhibits to Abu Dhabi, and then they actually had that exhibition in Abu Dhabi for a limited time. Now, how it helped Abu Dhabi government or corporation with the use of this brand, it brought international spotlight to that city's multi-billion tourist industry. So it's a classic case of goodwill, brand equity being licensed, and brand extension. So this is one example that I thought I should quote. Now the second one, this case study, I was fortunate to be part of this deal. And in this deal, one of the leading data research company collaborated with life science data management company to license certain process data on clinical trials using their proprietary method. So they actually license certain processed data to the data management company. The objective was to create a customized treatment for cancer patients using their gene sequencing. Because of this, licensing arrangement, the data management company or the life sciences company, which is the company B, as you see on your screen, they picked up this so well that now in no time, that data management company has become a market leader in this domain. So, that's how you can leverage licensing collaborations to your advantage. Now, let's talk. And now turning your attention to this slide, now that we have seen different types and examples of collaboration, Let us now closely analyze the structure of any collaboration agreement. And before we delve into the collaboration agreement structure, let's address a common question that may arise, and it's a frequently asked question as to whether is it legally mandatory to sign or write a collaboration contract or an agreement. And the answer is a qualified no, because if you look at patent trademark assignments, certain equity transactions, a written form of contracts are mandatory, but barring those purely in the context of collaboration, those may not necessarily be binding. But that's a theoretical debate. But having a written form of collaboration agreement always has a better enforceability. And tomorrow, if there is a dispute between two parties, and in the eyes of law, if you have to go and prove your case, a written form of contract always has more evidential value over the oral agreements, and therefore it is highly recommended that you document and you have your collaboration agreements in written form. Now, the last and not the least, if you have a written form of collaboration agreements, apart from the legal aspects, the collaboration agreement also regulates and brings some sort of a formal framework in establishing the clear expectations, and then you're clearly slated to go for a success under a collaborative endeavor. In the next slide, I have very, at a high level, I have done a comparative analysis between or a difference between a joint venture partnership sort of a deal versus a collaboration agreement. Now, the reason why I thought I should bring this slide up is many times companies do get confused with the nomenclature. Whether you call it as a joint venture, a partnership, or a collaboration, ultimately it's all governed by the content and the exact nature of what is written in that document. So let's start off with the joint venture or partnership agreements. They're generally some sort of a special purpose vehicle. So you actually create a spin-off entity, or they're called as spin-offs, where you distribute equity shares, stocks, proportionate to the capital that the parties infuse or the role that you're playing. So, these are not per se collaboration agreements. Those could definitely be also collaboration agreements, but from a business standpoint, when we talk about collaboration agreements, we are talking about a non-equity based, no ownership sort of an arrangement where parties come together for a specific purpose. They look at collaboration, they do their job, and these are generally short-term sort of arrangements. Of course, we have also seen collaboration arrangements which are long-term; they run in perpetuity. But your ability to exit that conversation or arrangement is easier. The structure is more agile, it's more flexible, it's more linear in nature. And when we talk about the risk and reward distribution in the joint venture or a partnership sort of an arrangement, it all is based on your holding patterns, the stakes that you have. It's all the valuation and what the profit and loss ratios that you agree. But when we talk about collaboration, this is purely governed by your revenue share arrangement, whatever license fees that you may agree in the contract, or it could sometimes be performance-based conversation also. Now, while we would segue into the composition and legal clauses of collaboration agreements very shortly, you pick up any collaboration agreement and broadly you would see a common structure of collaboration agreement consisting of the scope, the roles and responsibilities, the obligations, the divisions, different delivery methodologies, dispute resolution clauses, the ownership aspects. Then there are key commercial clauses, and then there are key legal clauses, and you will always see certain boilerplate cookie cutter clauses that you will find in any collaboration agreement towards the end. So this is by and large a global universal structure of collaboration agreement where the skeleton remains the same. Of course, the content and things under those would vary depending upon the nature of that engagement and the industry. Now let's shift our focus to a few slides where we'll explore the key clauses of collaboration agreements. And let me start off with preamble and recitals. These are introductory sort of sections that you will find in any agreement, and there is a basic stuff written out there: the name of the parties, registered office or address, what is their exact role that they're playing, and whether you're a licensor or a licensee. That's the example when I meant role, or whether you're the one who is entering into a collaboration agreement with a startup. So on and so forth. So the preamble clauses only talk about, uh, you know, the background. But if we look at the recital clauses, they actually provide some sort of a historical context of the collaboration, or as to how the parties have arrived at an agreement to collaborate with each other. What is their high-end objective? They could at times look aspirational in nature, but if you happen to be a party, try and write those clauses in a very factual way where you just talk about the background. Don't use any superlatives or sales language when you look at writing the background as to why you have come and what you're trying to do there. Now, why these clauses are important legally is because they set the stage for a formal agreement. They create a foundation for interpreting the substantive provisions of a collaboration agreement that follow eventually. So this is actually some sort of a baseline that you create when you enter into an agreement. Now, shifting gears slightly, we now have reached to the core topic of this session, which is the legal guardians, where I have actually covered the key legal concepts and clauses that you will need to know when you're approaching any collaboration agreements. And they're on your screen, and I'll explain these concepts one by one. There are many more I have not covered. I thought I'll just pick up the key ones. So the first and the foremost is the warranty clause. And warranty in any contract simply means a statement of fact, which factually is correct. And if you have relied upon it and eventually if it turns out to be incorrect, then you get a legal right to claim compensation that you have suffered because of your reliance on that statement. And it's very common that you will see every collaboration agreement would talk about certain warranties being sought from a collaborator or from both the parties, depending upon the role that you're playing in that contract. But broadly, if you look at if you look at the warranties, there are two different types of warranties. One is generic warranties, and another is specific warranties. When we say generic warranties, you will say that I do have a full power and authority to enter into a contract. I warrant that I am going to comply with all the applicable laws. But there are also very specific warranties where, let's say, if you're actually assigning some invention, there is a software that you are licensing to someone, or there is development of software for somebody else, then you would be very typically asked to provide a warranty to say that the software or the product that you deliver will not infringe upon somebody else's IP. There will be a specific indemnity to say the product that you're giving it to me, please give me a warranty that it will perform as per the specifications for 1 year, for 3 months, for 60 days, 90 days. So the concept of warranty period actually emanates from this concept of the warranties that you see. So broad and generic and specific warranties. These are the two concepts I thought I should clear. Now, the last part of the warranty: what happens when you breach the warranty? Do you get the right to repudiate that contract, to exit that contract, to reject that services? The answer is no. You get a right to claim certain compensation, and of course, and therefore, generally, you'll find certain mechanism being built into any contract which says if there is a breach, then within a reasonable period of time, I will do following things to fix those reported issues. And they normally have someone sending out to you to fix some of those issues, and so on and so forth. So that's the legal impact of warranty if there is a breach of warranty. Now, I always call this slide that you see as a heart of any contract. And even if you miss out all the things that I have talked about in this particular session, and if this particular concept stays with you as you are learning in this session, I think all the efforts are worth it. So I'll first explain this concept followed by certain examples. So by law, if your contract has a written cap on your monetary liabilities in case you're faced with a lawsuit or claim arising from your contract with the other side, then the other party can legally recover damages, but they cannot be more than the capped amount. So I'll explain that in a simpler terms by giving certain examples. So let me share one example. If in a collaboration agreement there is a delay from you in shipment of certain goods, and that has caused losses to your collaboration partner worth 1 crore rupees, and that's a direct expense. And if your collaboration agreement has a limitation of liability clause where you have capped your liability to 25% of the actual losses, in that case your collaboration partner cannot claim more than, in the present case, 25 lakh rupees from you. So if it's a 25% of the total damages is the liability wording, then the maximum that your collaboration partner can claim from you is going to be 25 lakh rupees. So naturally, this clause favors a party who has drafted that clause originally, or at least who has negotiated that clause very well. And therefore, you could imagine that this is one of the highly negotiated and most contentious clause. There are certain exceptions where you cannot, by law, cap your contractual liability, but those exceptions are very straightforward. If you have committed a fraud, if there are criminal acts, or there are certain liabilities that cannot be capped by law, there you cannot really cap those liabilities. And I'm going to talk about those in the next slide. There is this concept of direct and indirect damages. So indirect damages by law cannot be capped, but direct damages can be capped. Now, how much should be your liability? It all depends upon where exactly with whom you're negotiating the contract, which industry you belong to. But broadly, it could be the fees that you may have received in last 1 month, in last financial year. It could be your royalties in last 1 quarter. It could be twice or thrice of your fees. So this is something that you can negotiate depending upon what the industry standards are. But you can cap your liabilities to anything that both the parties mutually agree, and which is also reasonable in nature. Now, the reason why I'm talking in detail about this clause is, let's say you're signing up for a collaboration, you're entering into a collaboration agreement with a company, but your agreement does not have this clause. What is the legal effect of that? The legal effect is, in absence of this clause, your liabilities will be treated as uncapped liabilities. And therefore, it is always recommended that when we talk about collaboration, you always try and write this clause which says, if anything goes wrong, my liability is not going to be so and so. Now, as I mentioned to you earlier, there are 2 different types of damages, and damages is, in a simple words, compensation awarded by a court if you are facing a lawsuit, and that's what you're able to, through a limitation of liability clause, cap it. So the damages are of a direct and indirect in nature. And when we talk about concept of direct damages, these are sort of liabilities that could naturally arise in the course of your business for breach of contract. And should a breach happens, the party already know on day one when they entered into this contract, these liabilities would naturally arise. And I think the example that I quoted earlier, that delay in shipment, let's say, you're entering into a contract with a dockyard or a shipping company, and you delay the shipment of those goods to that dockyard. And because of that, that shipping company gets slapped with a fine from the dockyard, from the port authorities, etc. Those expenses are something which are reasonably foreseeable by you, and therefore those will be treated as direct damages, and those could very well be capped through your contract. Now, the second example is, you have delivered certain goods or services. There are defects. Your collaboration partner has come back and reported those issues, and despite multiple efforts, you are unable to fix those issues. In that case, the cost of getting those goods repaired from a third party will be treated as a direct damage. So direct damages, again, are something that could be capped contractually. But when we talk about indirect damages, and I'll give two examples, because of deficiency in your services, my market value has gone down, or a claim which says you did something wrong because of which my goodwill has suffered. These are the classic examples of indirect damages. Those cannot be capped by law in India. And of course, what is direct and what is indirect, this is something that the courts decide. You have to go through a formal court proceedings when we talk about the liability clauses being sort of used or exhausted. Now, let me talk quickly about indemnity. I'm sure you must have heard of this term before. It's some sort of a contractual security or an obligation where a party promises the other party to compensate the other party for the losses, damages, or any liabilities that may arise in the future due to promising party's action or by action of a third party. So the person to whom the indemnity is offered receives some sort of a security that it will be protected from a financial harm if that results from a specified breach by the promiser. Let me share an example. Let's say a company A and company B have collaborated where A's product and technology is being rebranded and sold by B. So let's say A is a product company, B is a white labeler who has rebranded that and sold it in the market. And the moment B starts selling that product and A has given B some sort of an assurance, A has given B an indemnity that if anything goes wrong, if there are any delays, if there is an infringement, if there is any issue with the quality of my goods, then I will indemnify you. With those assurances, let's say B starts selling that product in the market, and then company C comes and then sues company B, saying that your product actually is infringed my IP, my copyright. In that case, B can actually go back to A and say, look, you have given me an indemnity, I'm triggering my indemnity, and then A has to actually pay all the compensation that the courts may grant for such infringement. Now, is that all? Is that what the indemnity clause covers, or the concept of indemnity covers? Not at all. As per section 125 of Indian Contracts Act, there are multiple different things that you can recover when we talk about the concept of indemnity. You can cover the damages, you can cover the cost that you had to pay, and those costs could very well mean your internal investigation cost, the cost of engaging your defense counsel, or if you go and compromise something with the other party, you get into a settlement agreement. Even those costs are generally covered when we talk about the concept of indemnity. Now, indemnity clauses always come in a package where you will see this couple of different phrases being used. It says hold harmless, indemnify, and defend. Now, simply put, duty to defend and hold harmless, or duty to defend actually means a promiser has to defend your claim. And if you happen to be the company who has received that indemnity from the promiser, from the moment a claim is instituted against you. So if you're a party B and there is a claim from party C, and if there is a language in your contract which says you will defend me, in that case you need not have to you also pay the expenses of hiring those attorneys or lawyers to fight your case. You could just pass that claim on to the company who has given you an indemnity and duty to defend, and then that person or that company has to step into your shoes and lead the defense. So that's duty to defend. Now, hold harmless is one very interesting concept where it indicates that if a promiser of the indemnity is also sued, either because of you or a party associated with you, even then that promiser cannot sue you. So you can get those protections together when we talk about I know this is slightly theoretical, but the idea is to at least walk you through some of those basics so that as to how those indemnity clauses generally are formulated. Now, I do have some practical tips for you. I'm sure you will not find this to be a little theoretical. First and the foremost is when we talk about indemnity, and let's say if you're the one who has been asked to provide an indemnity, ensure that those indemnities are limited to the beneficiaries that that you can cater to, and it's very common that indemnities are also being asked to be provided for subsidiaries, affiliates, clients, employees, agents, and whatnot. So if you're the one who is being asked to provide indemnity, limit your indemnity only to your collaboration partner and not anybody else, at least as a first going position. Now, for what purpose and instances you should provide indemnity? It's a very common technique where you will be asked to give an indemnity for any and every breach under the sun. That language will say for any breach of the terms and conditions of the agreement. Don't agree to those. Try and negotiate those to specific instances. Don't attempt to act like their insurance company. Indemnities could be very societal. They bring their own nuisance values when we talk about indemnity. There are certain standard exceptions and geographical limitations that you may wish to also consider when you're negotiating those indemnities. And of course, at the end, you need to ensure that there is a formal process laid down when the other party, desires to enjoy your indemnities. They can't come to you after 1 year and say, please indemnify me. I got sued last year, and that entire 1 year has gone. Your ability to defend that claim also has gone. So indemnity clauses, be extremely careful when we talk about negotiating those clauses. I think you should always take some legal advice, at least when you're negotiating indemnity clauses. Now, if you are collaborating with a foreign collaborator, the most commonly asked question to me is which jurisdiction and the laws I should agree for, and how would I look at the dispute resolution clauses in my collaboration agreement. So I thought I'll cover that slide for you. So let's dwell into those aspects. Now, this is just as a FYI, a lot of what we do today in the international trade sector from a legal engagement perspective, like we enter into commercial contracts, we look at international arbitrations or dispute resolution in India. All of that is governed, or it is stemming out from something called as UNICETRAL framework, and that has laid down a framework for harmonization of the modern law. And most of the countries in the world, they have largely adopted that. This was just as a FYI slide, but this brings some uniformity in the thought process when we talk about international disputes. Now, the common trend that we see in the market is parties prefer to settle disputes out of the court today. Their preference is towards something called as alternative dispute resolutions. And there are a lot of good options. Mediations are there, arbitrations are there. And generally it is recommended that you go for institutional arbitration in international disputes over an ad hoc. Now, there is this very old argument as to whether going to the court directly is more viable, less costly, expensive. I'm not going to get into too many nuances, but when it comes to cross-border disputes, if you're dealing with an international collaboration, always prefer to go for institutional arbitration. And if you see on your screen, I have actually taken out some names: Singapore International Arbitration Center, LCIA, ICC, AAA, which is American Arbitration Association. All of these are institutional arbitration centers. They have their own rules. You could actually adopt to those rules, and then you could go for those arbitrations. You insert those clauses on their websites. They have those model clauses that they have added. Pick those up, put those as a part of your collaboration agreements. Now, in the cross-border engagement setup, the parties also can mutually agree as to which courts of which country and of which jurisdictions, which legal system can govern the disputes that may arise between those parties under this agreement. So if you are an Indian startup collaborating with, let's say, a US entity, the preference from the US entity would always be to have the US laws as a court. And naturally, you would push for the Indian laws with the courts of your city to govern that disputes. But cases where there is no meeting of mind as to which law and jurisdiction to go for, parties generally should agree, or they ideally should consider to go for neutral jurisdiction. So in India and US, you might pick up Singapore or Switzerland as one of the, or you could look at English laws or English codes as a good viable option for you. Now, moving forward, let's discuss and explore the key commercial clauses in collaboration agreements. And what you see on your screen are some of those examples, and I'm going to actually quickly talk about those. I'm going to cover this in next 10 minutes or so that we don't really overshot on the time, and then I'll take some of the questions. So I'll start off with the IP ownership, and there is this concept called as works made for hire. So if you're engaged to develop something specific for your collaborator, the resultant work product that gets generated, and if there is a new IP that gets generated, something like a software or a design, then the ownership of that IP will belong to that other collaborator for whom you have developed that IP. So that's why it's called as works made for hire. So anything that gets generated in the process is called as foreground IP. But in the process, if you have used your own technology, a platform, anything which is already a patented invention, process, whatever, that pre-existing stuff will be treated as a background IP. So foreground IP and background IP, these are the two concepts when we talk about the ownership. So you'll always find clauses which talks about the ownership. Now, joint IP is a slightly hazy concept legally because you have a lot of limitations and restrictions as to how you're going to monetize that IP at the end of the day. But joint IP as a concept also exists. So if two parties come together and they develop something during the course of the project, then that is treated as a joint IP. Term and termination. Generally, collaboration agreements are time-bound, with exceptions where they could run in perpetuity. But accordingly, you need to ensure that you agree for term clauses carefully. I've always seen, or many times it happens that you have signed up for a one-year collaboration agreement, but the clauses survive, and those obligations could run in perpetuity. So through survival clauses, there is always some obligation on you to keep certain things the way it is. There will be certain recurring obligations on you. So always check as to which model of term suits you better. Now, when we talk about termination, it's a critical line item, and you have to think through your exits really well. You have to factor a longer notice period if you want to just exit for your convenience, or if you want the other party to exit for their convenience, which we also call that as a planned exits or planned terminations. But at times, for various reasons like deficiency in services, non-payment, market factors, ethical issues, or inaction by your collaborator, you might feel a need to exit that conversation or relationship. And in that case, you need to give out the reasons of why. You need to negotiate really hard to then create some process around that as to why you should not terminate. But all of those conversations fall within the concept of termination for cause. Now, generally, the notice period for the termination of cause is always shorter than the termination for convenience, because if you see something unethical, you can't just wait for 90 days or 1 year to have that termination for convenience sort of a conversation get over. You want to exit very early. But either ways, when we talk about terminations, always check the impact of termination. If there are certain unutilized services, there are certain license fees, if there are any costs that you have already incurred in anticipation of some business, and if you have made that aware to your collaboration partner well in advance, some of those things will have to be spelled out very clearly in the termination. Payment terms, I think it's a straightforward, depending upon your engagement. You could look at the milestone, periodic, back-to-back. Now, if it's a royalty deal, you would always want to fight and have some sort of an audit clause so that and you have visibility in terms of whether what you're getting paid is aligned with the actual sales that is happening. And then there are different remedies if there is a non-payment that happens. So, your collaboration agreement will always spell out some of these nitty-gritties in detail. I'll take a minute to explain acceptance because it is one of the important contractual tool that you must consider to add in your collaboration agreement as to what method of acceptance should be adopted, what should be the criteria, what are the timelines, what happens if the acceptance has failed, within what time parameter the acceptance should happen. All of that you need to know has to be spelled out clearly when we talk about any deliverables and their acceptance. And in absence of those, it could be a troublesome for both the parties. If you're the one who is providing your product or services to your collaboration partner or to their customer, you may want to also have a clause of deemed acceptance, which says, if I don't get to hear from you, either a yes or no, I will treat that as your deemed acceptance of my deliverable. So that's the concept of deemed acceptance. Now, we talked about exclusivity earlier, and I have already walked you through the benefits of collaboration. So I'll skip the part of advantages of exclusive arrangement, but I want to just quickly walk you through some of the pitfalls, because at times getting into an exclusivity arrangement, and especially if you're a small entity or a startup, could be really taxing. And I have seen that firsthand with many of companies where today they are struggling because they had to sign for exclusivity. There were commitments made, but the other party, given their size, market, they really didn't follow their contracts in the letter and the spirit of that engagement. So there are disadvantages, and of course, one of them is you might find yourself to be limited in terms of your growth. There is a pure dependency on only one individual entity. Your competition could sort of look at this as an opportunity where they could collaborate with multiple partners, and they could outgrow you. There is a heavy dependency that you have on that company. Of course, at times there could be limitations on your innovation, because in absence of this exclusive collaboration, if you were to collaborate with multiple partners, there could have been some growth opportunities for you. And of course, it has limitations in terms of your agility. So it all depends upon the equations and the commercial outputs or the objectives of your company. And I have just given one very quick case study here, where a pharma giant actually, so let's say company A, which has got a proprietary formula or know-how in the space of tissue engineering components, has got certain patented material and a process to reconstruct the bone tissues. So they have already taken that patent, and there is nobody else in the market. They have no competition. This is pure, it's a new technology that they have developed. Now they have two competitive offers. One is from company B and another is from company C. Both those offers are more or less same, where they're saying that you give us that formula, you give us those methods and material, we'll mass produce that, we'll go in the market, we'll sell it, but you need to give us a some sort of a license to do that. Now the company B is saying, you give me a perpetual but non-exclusive license. I'm not going to pay you any upfront fees for licensing that to me, but I'll give you a commitment that when I have any sales proceeds, I'm going to pay you 30%, provided it's a non-exclusive deal. Company C, on the other hand, says the offer of company B remains more or less the same, provided that you make that as an exclusive license. I will give you 50%. So whether it is 50 versus 30, that's the conversation and the call that company A had to take. And then we all need to sort of think through it as to whether the deal offered by company C is better or the deal offered by company B is better. In my view, of course, the deal offered by company B is better because it's a non-exclusive license arrangement, and nothing stops company A or nothing precludes company A from going to company D or anybody else in the market and multiply their revenues, which otherwise has not been possible because company C is saying it's an exclusive license. So this is just one example of exclusivity. Insurance, I think I will skip that this particular slide, but I'm happy to take any questions you may have. But this is not a deal breaker as long as the cost associated with the insurance that you're required to buy. And if you're able to factor it, don't look at those as deal breaker clauses. I want to spend next 1 minute on the restrictive clauses or restrictive covenants. And sometimes you might come across situations that may demand that the other party must and should be prohibited from doing certain activities. And therefore, it's common to insert such restrictions in collaboration agreements. Non-circumvention of customer is one of the common ones, where you actually prohibit your collaborator from bypassing you and reaching to your customers when you're introducing that customer to your collaboration partner. Non-solicitation of client is another closer to the earlier non-circumvention of custom, with a small difference that the collaboration partner is actively prohibited from soliciting business from the companies who are your direct clients already. So here you're trying to ring fence your boundaries by saying you will not do certain things if I collaborate with you. Non-compete is a straightforward one which prohibits parties from engaging in a similar or competing business with any another collaboration partner, and not necessary that non-compete obligation could happen when you both are together. It could actually run for a period of 1 or 2 years even after you have terminated that contract. And the last one is no hire of employees. Essentially it sort of protects your employees being hired by your your collaborator. So you're at least taken care well with some of these basics when you're doing this collaboration. Now, publicity in collaboration is another very common sort of a clause that you will come across. And publicity clauses ensures that parties do not sort of make those deal announcements, or they go in the public domain without having your content, formally, sort of validated by you. And therefore, as an inventor, if you want to really have your name published, if you happen to be a large company, you will have your own names and logos policies, which color scheme that you would like your collaborator to use, your logos. So generally, collaboration agreements do contain clauses which either outlines the process of how the other party can go and do publicity, marketing, brand, etc., etc. But those are some basic clauses that you will see in a collaboration agreement. So if you happen to be a startup, you will always negotiate and say, look, now that we have collaborated, I don't need to come to you every time. I should get a default authority from you to use your name, logos in my marketing content, so on and so forth. But if you happen to be a large company, you would always want to ensure that the collaborator does not just go and use your name and logo without your permission. So that's the publicity clause. And I think with that, we are headed to the very last segment of this session. I'm almost done with my session. I want to cover the must-haves of successful collaboration, some practical tips. And the first tip is when you get into any collaboration agreement, please define the timelines for the items that you think are crucial for success of that collaboration. If there is a breach, negotiate for contractual penalties if those SLAs are breached. Operationalize your contracts. Take out those key obligations and convert them into some sort of a tangible actions. Identify your team members. Ask your team members to monitor compliances, not just by you internally, but also ensure that your collaboration partner also is following some of the key obligations both the parties have agreed. Consider setting up some sort of a reward system like service level credits, where you get some rewards for a breach of service level agreements if there is a breach by your collaborator. So pick up something like a free extra hours of work, certain discounts, certain efforts, additional payment terms, delaying payment, etc., etc. If you see consistent breaches in the SLAs. Minutes of the meeting even today are highly underrated stuff. They do carry high evidential value, and they are really helpful when we talk about disputes or disagreements. Now, don't shell out equity, and this is more relevant in the context of equity collaboration, where often it's seen that the co-founders or the founders shell out a substantial portion of their equity early in the game, and this damages their valuation, their decision-making powers in their own work subsequently. Second last, a trained contract attorney can actually provide you with excellent insights in curating a customized draft of collaboration agreement. Don't get into a copy-paste mode. That will really have a damaging effect. You never know, a simple, single, small, wrong clause actually could turn fatal for you, and it could have some potential to push you out of your business. Last but not the least, keep an open, regular lines of communication. Provide and insist for frequent updates. Ensure you document your reports and ensure there is a transparency and accountability. I think negotiating and enforcing a collaboration agreement requires some proactive and diligent approach by all the parties. And by doing some of these things that I just mentioned, you can increase the likelihood of successful and enforcement collaboration. So with that, I wish you all the best, and I conclude my session. I'm happy to take any questions you may have if there is time for us.
Thank you, Nihal. Thanks a lot. That was a very nice talk, very interesting. I mean, you've tried to bring in a lot of concepts here. So before we start the questions, let me just tell everybody that there's a link to a feedback form in the chat box. Please do give your feedback, because that helps us keep improving our events as we go along, and also is shared with the speakers as well, so they get some inputs on what was useful and not, right? Okay, so Nihal, I'll just go to the first question, which came from Bipin Deshpande. Can a collaboration include technology licensing? How does one track, monitor actual sales volume by the licensor or collaborator? Two different questions. First thing is, can a collaboration agreement include technology licensing?
Yes, sir. It can, and I think we touched upon those topics where technology transfers, technology licensing are one of the most common types of collaborations that we see in the market.
And what do you do in terms of when you construct a collaboration agreement, if there's licensing inside it? So I think, the kind of thing they might have in mind is consider a joint development agreement, right? Or something where somebody's funding the development and they build in a licensing segment into it, saying we'll do this project, but included in it is a license that, we'll fund your rest of your development, but we would have a license to it, right?
Yes.
Do you want to comment on that a little bit?
Yeah, so it happens that licensing could very well be a part of your larger deal where there is a barter that is happening, and you have some part which is coming to you as a part of licensing, and there could be some equity which is also being shared. So it all depends upon how you want to structure it, what are the nuances. But yes, just to keep it short, collaboration agreements do come with some of these different flavors and shapes when we talk about technology licensing. I'm happy to actually discuss with you in person, or you can reach out to me. I'm going to share my email with you. I'm happy to just consult you on those aspects in detail.
Okay. The other question which I had also wanted to ask you was, but before that, Rajneesh Prasad's question, how to negotiate on governing laws clause until the other party, which is a larger entity in most cases, dictates that with a simple statement that it is standard clause approved from their legal department to have the jurisdiction of their own.
Yeah.
Startups whose interest is more on creating collaborations accept that, although with a heavy heart, rather than contesting over jurisdictions. So is there some way one can work around such situations?
Yeah. This is very common where you'll be asked to sign that contract as is, and you have to take a call as to whether that collaboration opportunity is more important than you possibly looking at some of these clauses, which I call it as paper tiger clauses. They're not going to get triggered unless there is really you miss the bus and there is really something wrong with the way you have collaborated. So again, that's the commercial part of that conversation. But as I mentioned to you earlier, people generally would be amenable if you pose them options which are neutral or closer to them. And if not exactly what they're asking for, you could. So let me give you an example. If you're dealing with a US entity, and if they ask for Californian laws, and if you happen to have someone in Delaware, or you have an entity in Delaware, or some which is closer to Delaware, you would always go for some other jurisdiction, or the courts there will be Delaware. So it all depends upon how do you do it. But my experience tells me that if you propose something which is neutral, generally companies would be amenable to it. Of course, when it comes to an argument between a privacy versus a company policy versus merits, company policy always wins. So there you can't do anything about it. Yeah.
So even in the governing laws, is there a third-party law that you can, another country's law or something like that?
Yes. So especially for the Indian companies, the English laws work, really fine. Switzerland nowadays as a country and as the laws, as a legal system is actually looking at that as a hot destination. They are creating, amazing courts. They have got great jurisprudence, which is getting developed over a period of time. So they're looking at this as one of the opportunities for them to even, look at that as a business opportunity for them. So English courts, English laws, Swiss courts, Swiss laws, Singapore are some of those laws which are slightly in between when we look at the legal systems in civil versus common laws, and therefore these are something that is generally recommended.
Okay. Recently, we've also been seeing some of the government departments putting down ICADR kind of dispute resolution clauses. Do you want to comment what that is?
So,
and how does it compare with other things that you had put on the screen, Singapore and all that you had mentioned, right?
So again, these are all, see what has happened is if you look at the old days, not very long, a few years ago, and we happened to fight one of those cases where one of the government PSUs actually had put a clause to say that we will appoint our own arbitration, that arbiter, and that whatever award which is given by that arbiter is going to be final to you. Over a period of time, through Supreme Court and through different jurisprudence, there is a lot of clarity, and there was a lot of bashing that has gone into it where it stands now. So the inclination is now towards those alternative dispute resolutions where you go for some institutional arbitration, and there are really well institutional arbitration centers which are being built. We have something in Pune within the ILS Law College premises, and there are many more which are getting developed. So the idea is to go with those because those are time-bound matters where you'll be given a mandate to finish that arbitration within a particular time frame. The costs are also manageable because you actually have a rate card. There is a facility which is generally built in a particular premises where you don't get charged like the way you would otherwise get charged of a 5-star prices, because if you look at those ad hoc arbitrations, you get a retired justice from a high court, they would tend to meet in 5 stars, and you would end up just spending money on conducting those arbitration proceedings. So institutional arbitrations therefore are really relevant and more crucial.
Okay, great. That's good. Are there any other questions? Please keep putting it down. So I think Ganesh has a question here. Nihal, many times we do have well-drafted agreement, but still not feasible to enforce it. What are the practical aspects you should keep in mind in collaborations and in context of enforcement, I think?
Yeah, exactly. You need to follow your agreement in totality. You have to actionize your contracts, and that's the only way you go about it. And it requires a clear communication. It requires you to take a stand with your collaboration partner, with your investor, with your customer. If you don't see anything going wrong, anything going right the way you both have agreed. And of course, some of those things you could put it in a very subtle way. But the idea is to convey and trigger those early signs and sort of communicate that to your other side. Otherwise, you'll never be able to sort of enforce some of these contracts.
Okay, I think Mugdha has requested everybody to sort of come online. Can I request? Did you want to share your email address, or else you can unshare your screen, please? Yeah, good. That's, I think, important for people in case people want to get in touch.
Yeah, so you'll see my email ID there. Feel free to write to me with any questions. I'm happy to guide you through some of those questions.
So just give us a moment. We are going to click a group photo also once Nihal stops sharing the screen.
Sure.
His email address is in the chat box for everyone to refer. And our feedback link is also there. My name is Dr. Mugdha Lele, and I have hosted this series from Venture Center. And this is my colleague Sharvari Naik, who has been part of this entire series. You must have got several emails from her all throughout these 9 months. So thank you, Sharvari, for supporting the entire initiative. So Sharvari, requesting you to take a snapshot and requesting everyone to switch on your videos if possible.
I'll stop my screen now.
Yeah,
Just for a moment, please.
just give us a few minutes before we click. Sharvari, you can say 1, 2, 3, whatever.
Yeah, so I'll click in 3, 2, 1.
Did you take it?
Yes,
Yeah.
she is taken it.
Okay, good.
Thank you.
Thank you very much. Nihal, we have many more questions, but I think we will collect all of them since it's about 5:20. If you don't mind, we'll stop at this time and we will get back with a few questions for you. Is that okay?
Sure. Yes, sir.
Thank you very much. Actually, it was a very interesting, and I think you had collected a lot of useful information for us, and this will be really useful for our whole ecosystem as well. Okay.
Thank you. Thank you, everyone.
Over to
Thanks
you,
for
Mugdha.
joining.
Yeah.
Thank you, Nihal, for this session. And again, a gentle reminder to all of you to please fill in the feedback form before you quit this session. And we do want your suggestions on the future topics because we are planning to come back with the entire set of new topics in this series after a few weeks. Thank you, everyone, for joining.
Thank you.
Bye.